This autumn will see a significant change in the way in which social landlords have to respond to hazards in their tenants' homes. On 27th of October, the first phase of Awaab's law will come into force. Awaab's law is named after the young child, Awaab Ishak, who tragically died in 2020 from what the coroner found to be the effects of extensive mould in the family's flat, which was a social tenancy from Rochdale Borough Homes. The landlord had failed to act on the family's complaints about the mould. Since 2019, under the Homes Fitness for Human Habitation Act 2018, landlords have been under an obligation to take steps to remedy defects in rented properties that present a risk to the health and well-being of the occupiers. This includes mould caused by condensation, for which landlords were not previously liable. But the landlord was only in breach of its obligations if it had not remedied the defect within a reasonable time of being told of the problem. There has been a lot of dispute over what a reasonable time to respond is, and many landlords respond to complaints slowly or only by doing temporary works rather than fixing the issue properly. Awaab's law changes this for social landlords. What the law does is to create an obligation on the landlord to respond to complaints and to start work to remedy defects within a set timescale. It is a duty to the tenant, who can enforce it in the courts if the landlord doesn't comply. The first phase of Awaab's law sets out what must be done in respect of damp, mould and fungal growth, and also what must be done when there is an emergency hazard, something that presents an immediate and significant risk of harm to the occupiers. When there is an emergency hazard, this must be addressed within 24 hours, either by remedial work or by decanting the occupiers to a safe place while the works are done. Where the landlord becomes aware the property may have a significant hazard of damp, mould or fungal growth, they must first investigate within 10 working days, that's 2 weeks. Within the next 3 working days, the landlord must provide the tenant with a report of their findings, any actions required, and the timescale for the start and finishing of those works. Where there is a significant hazard, the landlord must start remedial works within 5 working days of completing the investigation, and the works must then be completed within a reasonable timescale. If the property can't be made safe within those 5 working days, the landlord must provide temporary accommodation for the occupiers, at least until the property is made safe. These will be legal duties on the social landlord, which they can't avoid. Tenants will be able to enforce those duties if the landlord does not keep to the requirements. While this first phase only addresses damp and mould, other defects like excessive cold or excessive heat, noise, electrical hazards will have similar requirements set out in 2026. And eventually, the same rules will apply to private landlords as well. Anthony Gold have had the safety and well-being of tenants at the heart of what we do for many years. We played a part in making the Homes Fitness for Human Habitation Act into law by drafting it with Karen Buck MP. And the clarity of the timescales for action in Awaab's law is something we very much welcome, and we will be working for tenants in making sure that landlords comply with their duty to keep their tenants' homes safe and fit to live in. Anthony Gold will be saying more about Awaab's law and the ways in which tenants can use it to enforce their rights in the coming months.